Straight ahead on Law and Crime Daily. Attorneys for Lori Vallow Daybell want her trial moved out of the same county where the bodies of her two murdered children were buried. The request filed as the doomsday mom stands incompetent to proceed. Britney Spears' mother petitioned for her right to hire her own attorney. The legal battles in the pop star's conservatorship as some announce they're stepping down, while others say not so fast. Kyle Rittenhouse's attorneys signal more possible defense strategies, wanting to show that one of the deceased victims was a sex offender. 6 months since the deadly insurrection at the nation's capital, the newly released videos the FBI is asking for your help to identify suspects, and why the so-called QAnon shaman won't be getting out of jail. Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmeyer along with Terry Austin. We begin with the so-called doomsday mom, Lori Vallow Daybell. Her attorney is filing a series of pretrial motions while she is receiving mental health treatment. Lori Vallow Daybell's attorney is asking to move her trial out of Fremont County, Idaho. Defense attorney Mark Means says a fair and impartial jury could not be found there. In Idaho, Lori is charged with the murders of her two children, 7-year-old J.J. Vallow and 16-year-old Tylee Ryan, along with conspiring to commit the murder of Tammy Dabell, the wife of her fifth husband, Chad Dabell. Lori's case is currently on hold. She was deemed incompetent to stand trial and was transferred to a mental health facility. In the meantime, attorney Mark Means is filing a reservation of rights and defenses, notifying the court Lori will not waive her right to defend herself. And, in a third motion, Means is asking the court to show cause for why two of the state's witnesses should not be held in contempt for not turning over evidence to him. Means claims Chad Daybell's sister-in-law, Heather, along with one of the couple's friends, Melanie Gibb, refused to give him communication records. Lori is also facing charges in Arizona for conspiring to commit the murder of her fourth husband, Charles Vallow. Charles Vallow's brother told East Idaho News that for Lori and Chad, the death penalty would be the easy way out.
You know, I'll tell you something. She ain't crazy. That knew exactly what she was doing. And that's the truth. If and when she is found guilty of her charges, what's that, 4 conspiracies, death penalty, I don't know. I'd rather see her rot in prison for the rest of her life and enjoy that kind of lifestyle.
While the charges against Lori are eligible for the death penalty, prosecutors have not yet said if they'll seek it if she's convicted. Joining us today is criminal defense attorney Julie Roundelman and Terry Austin. Julie, with Lori Vallow incompetent to stand trial, why would a lawyer serve all of these motions?
So the simple answer is that she's not going to always be incompetent. The goal is right now is to give her rehabilitation so that she'll have an opportunity to be able to be tried before a court of law. And so the defense is doing what he should be doing. He's getting ahead of things. He's making sure that all his ducks are in a row, because eventually when she is found competent, he doesn't want to be in a position where the judge says, you know, too little, too late. So he's getting it done now because eventually it will be needed in the future.
Makes sense. Like you said, get your ducks in a row. Terry, the death penalty wasn't on the table when Vallow was arrested, but since then, a number of murder charges and even conspiracy charges to commit murder have been added. So could that change?
You know what, Brian? Anything is possible unless we already have a confirmed plea deal that has been approved by the judge, and we don't have that. If any case calls for the death penalty, it is this case. I don't think death is the easy way out, to tell you the truth. It's a severe punishment, obviously. We have multiple murders. We have murders of children involved. So I definitely think that if the prosecution were to decide to bring the death penalty against either Lori or Chad, they would absolutely be right to do so.
Right. We'll see how that plan plays out. Sorry, for many states, you have to make them aware, either the court or the defense, that you're seeking the death penalty. Of course, we have not heard that as of yet. Thank you both. Now to California, where attorneys are gearing up for a big fight at the upcoming trial for Theranos founder, Elizabeth Holmes. Holmes is set to stand trial beginning August 31st for charges of wire fraud and conspiracy to commit wire fraud. She's accused of defrauding investors of millions and scamming doctors and patients at her blood testing startup. A judge has ruled prosecutors can present 13 documents between Holmes and the high-profile law firm of attorney David Boies. The documents were reportedly about Holmes' attempt to sue the Wall Street Journal. Julie, can you break down attorney-client privilege for us and why it might not apply to these 13 documents?
Sure. I mean, attorney-client privilege is basically that you have an opportunity to speak to your attorney without the risk of anyone finding out what you have to say. And that is something imperative in order for us to be able to go forward with any of these cases, whether they be civil or criminal. In this case, the judge's position is, wait a second, this isn't a attorney-client privilege. She didn't have a retainer agreement in writing with this firm. She didn't pay this firm out of her own funds. She paid it out of the corporate funds. And so this is a corporate privilege. And so therefore, those 13 items are potentially not falling into the attorney-client privilege that she so hoped would be used in this case.
Yeah, maybe the corporation is a client, but not Elizabeth Holmes herself. Now, Terry, do you agree with the judge's decision? And do you think Holmes could potentially appeal the decision even before the trial?
Yes, Brian, I do agree with the decision, and she could appeal the decision. That would be what we call an interlocutory decision, where you're having a decision made on a particular issue prior to the merits of the case. You have to have a couple of things. You have to make sure that the issue has been conclusively determined, and that has been done here. It has to be an issue that's separate from the actual merits of the case, and that has been done here. And it has to be unreviewable on appeal after final judgment. And I think that exists here too. So basically, the judge is making a decision here based on documents and discovery. And I do think she has the right to appeal that interlocutory decision there.
All right, we'll see if she takes that appeal and decides to go to a higher court before the trial starts, because these documents seem to be very damning against her case. Turning now to other top stories, the young woman who filmed the video of George Floyd's murder on her cell phone now says her uncle was killed by a police car, pursuing a carjacking suspect accused of multiple robberies. Darnella Fraser posted on Facebook saying her uncle, Lanil Lamont Fraser, was struck by a Minneapolis police squad cruiser. Investigators say the officer was chasing a suspect when it collided with a vehicle at an intersection. Minneapolis police has cost my whole family a big loss, Fraser wrote. You took an innocent life trying to catch someone else. Still ahead on Law&Crime Daily, why one of the jurors in the Robert Durst trial had to be excused. But first, more twists and turns in the Britney Spears conservatorship battle, why the pop star's mom is filing a new request on her behalf next. Back. Britney Spears' mom is speaking out in court documents backing her daughter's desire to take charge of her personal life. This comes as her current legal team resigns. Law&Crime's Anjanette Levy is here with the latest developments.
Brian, Britney Spears' mother, Lynn Spears, has filed documents with the court asking that the court allow her daughter to choose her own lawyer. Or in the alternative, Lynn Spears wants the judge to appoint an attorney of Britney Spears' choosings.
One by one, people who are part of Britney Spears' professional life are stepping away. Her longtime manager, Larry Rudolph, has stepped down, saying his services are no longer needed since he's been told Spears plans to retire. Now, Spears' court-appointed lawyer, Samuel Ingham, has filed documents with the court stating he and a firm he retained to help represent Spears will resign after the court appoints a new lawyer for her. The wave of resignations comes after Spears spoke during a June 23rd hearing in which she said she wanted the conservatorship to end. Spears' father, Jamie, has asked for a hearing to investigate his daughter's claims of abuse, saying he's been handling her estate, not her personal needs, since 2019.
I think the judges got little or no choice but to have a hearing. When you have the conservator asking for a hearing and wanting an evidentiary hearing, what is the judge to do?
California attorney Mark Garrigus has been following the story. Spears' contentious relationship with her father has been no secret. She's asked that her father be removed from the conservatorship as recently as last November. Jamie Spears suggested Jody Montgomery, the woman in charge of Spears' personal care, was to blame. But a spokesperson for Montgomery's lawyer tells Law&Crime Ms. Montgomery has no plans to step down as Ms. Spears' temporary conservator of the person. Ms. Spears, as recently as yesterday, has asked Ms. Montgomery to continue to serve.
Now, Lynn Spears says in those court documents that her daughter is perfectly capable of making her own decisions in her personal life. The next date for that conservatorship in court, next court date that is next week. Brian.
Thanks, Anjanette. Now, Julie, Britney wants to be able to pick her own lawyer and seems to suggest that she doesn't agree with her court-appointed attorney. What do you make of the court-appointed attorney resigning?
So it seems like everyone is resigning when it comes to the Britney Spears saga, and you know there's several reasons that could be happening. Is one is she's discharged them, she doesn't want to work with them, or two, they don't want to work with her. It's possible that the communication has been broken down to such an extent that they don't think that they can represent her properly. We obviously don't know the full detail. We do know that it's imperative that an individual be represented by someone that they trust and are comfortable with, and that seems to be what Britney Spears and her mother are asking for. And so that seems like something that they may very well be entitled to.
Now, Julie, I just want to highlight that phrase because that is a very important phrase. When communication breaks down between a client and a court-appointed attorney, that's one of the few ways that they can actually step aside and a court will appoint another attorney. Terry, Britney's mother, Lynn Spears, actually filed a motion requesting a private attorney with a list of demands. What exactly is she requesting?
You know, the very first thing she said, Brian, was, I need the court to listen to the wishes of my daughter. And I think that's very important. And the number one wish was the fact that Britney wants to have her own attorneys appointed, as we already heard from Anjanette, and that makes complete sense. And one of the things that she also, Lynn, mentioned in her court papers was that she thought Britney was very courageous during her June 23rd court appearance where Britney spoke out and defended herself. And I think most importantly, the one thing that she has confirmed in these papers is that Britney can take care of all of her own affairs. And she stands by her daughter, and she thinks the conservatorship should end. So hopefully the court will listen to her.
Yeah, the desire to hire a private attorney makes what Julie said even makes more sense, I would agree, in terms of where the family wants to go in terms of direction. And Janet, hasn't there been some reporting recently that suggested Samuel Ingram was more loyal to the conservatorship than to Britney Spears?
Yeah, the New Yorker magazine, Ronan Farrow wrote an article along with another writer with the New Yorker, and they talked about how there were people who were suspicious that he was really part of this conservatorship system and that he was making $500,000 a year or more. The New York Times also reported that Ingham may have made as much as $3 million throughout the course of this conservatorship through Britney Spears off of the conservatorship in legal fees. So that's quite a bit of money over the last 13 years.
Absolutely. Thank you, everyone, for that input. Now to Texas, where it was a rough day for a French bulldog puppy named Mario after two women stole him from a pet store. It happened in the city of Shenandoah. Petland store employees called police and said the women walked out of the store with the puppy and got into a car with no license plates. Officers found the car and pulled it over. The puppy snatchers were taken into custody and Mario was returned to the store safe and sound. Coming up on Law&Crime Daily, the shocking location of where a cadaver dog sniffed out a missing boy. Plus, looking back at the riots at the Capitol 6 months later, hundreds of defendants, more than a dozen guilty pleas. What's next in this unprecedented prosecution? Welcome back. As we come to the 6-month anniversary of the Capitol riot, a judge is ordering one of the key defendants to remain in jail pending trial. 6 months since the deadly insurrection at the nation's capital, 535 people have been arrested and 13 have pled guilty. The FBI says hundreds of more investigations are still ongoing and more serious charges are in store. On Tuesday, the FBI released 11 new videos of suspects assaulting federal officers, seeking the public's help in identifying them. But for one defendant whose identity has long been known, a judge denied his request to be released to an undisclosed secure location with his family. Jacob Shansley, better known as the QAnon shaman, is accused of storming the Capitol carrying a flagpole with a spear as a weapon. His attorney previously appeared on Law&Crime Daily saying his client was duped by conspiracy theories.
There is an alternate universe that happens to exist in this world, and sometimes some people embrace it and they move forward with it, and they have an issue. My client happens to, it doesn't take much to look at my client and say, you know what, maybe, just maybe, he doesn't fall within the bell curve of that which you and I would consider normal.
Back to break down the QAnon shaman's case is criminal defense attorney Julie Rendelman and co-host Terry Austin. Terry, do you agree with the judge in keeping the shaman in till trial, or could there have been another form of bail, like an ankle monitor, while he awaits trial?
I definitely think that the charges were serious enough so that he should remain in trial. And you have to think about whether or not he is a threat to society. Federal prosecutors actually thought that he was, and that many of the rioters were, because they made specific threats to lawmakers. And so I think if you keep that in mind, that is not the type of person you want outside of court, even if they have a monitor and they are being closely watched. So I think it was the right decision here.
It makes sense based on that fact, because with bail, you first have to consider, are they going to come back to court? And then second, are they a danger to society? Based on that point, it seems like yes to both. Julie, with such a high-profile defendant, do you think there is a plea deal to be made here, or should we all just expect a trial?
I don't know. I think one of the big problems that we have here is, and it seems obvious from even what the defense attorney said, is that there seems to be a mental health component, a problem with regards to this defendant. And when there's a mental health component, it makes it much more difficult to plead guilty because you have to acknowledge your guilt and you have to acknowledge intent. I mean, look, anything can happen. I think, at this point, the defense is standing, pretty firm in regards to defending his client. But again, it's still pretty early on. And at the end of the day, it's not unusual to see defendants plead guilty, particularly in these type of cases.
Absolutely. We'll see how that plays out. I agree with you, the mental health aspect, but also the video is pretty damning, and no one's going to miss him on any of those photos. Thank you both. When we come back, attorneys for Kyle Rittenhouse now pointing the finger at one of the victims. The legal arguments of the defense for the accused Kenosha shooter next. Welcome back. One of the jurors in the Robert Durst trial has been dismissed as testimony in the trial of the real estate heir has now resumed. Robert Durst is accused of murdering his best friend, Susan Berman, in December 2000. On Wednesday, the judge announced one of the jurors in the months-long trial must be excused due to medical reasons, bringing the total count of the jury down to 18 members. In court, attorneys are now reading transcripts from Durst's 2003 trial for the death of his neighbor, Morris Black. Durst was acquitted of murder, but testimony is allowed into this trial because prosecutors are allowed to offer evidence ruled as relevant. Now to Colorado for the trial of Mark Redwine, where one of the witnesses says a cadaver dog smelled human remains at the defendant's home. Redwine is charged with second-degree murder of his 13-year-old son, Dylan Redwine. Dylan's remains were found less than a year after he disappeared while on a court-ordered visit to his father. The dog's handler says it indicated multiple times there could have been remains at the first floor and near the garage of Redwine's house. The defense objected to this testimony, pointing out the dog could have signaled false positives and the scene could have been contaminated. Tune into the Law&Crime Network for gavel-to-gavel coverage. And in Wisconsin, attorneys for Kyle Rittenhouse want to be able to show a jury that one of the victims was a registered sex offender. Rittenhouse is charged with the murder of Joseph Rosenbaum and Anthony Huber, as well as attempted murder of a third man. Joseph Rosenbaum was convicted in Arizona for having sex with a minor in 2002 and was prohibited from possessing firearms. Attorneys for Rittenhouse say Rosenbaum started the fight with Rittenhouse, trying to take his assault-style rifle. Rittenhouse traveled from Illinois to Kenosha, Wisconsin during protests over the police shooting of Jacob Blake. Rittenhouse maintains he fired in self-defense. He's scheduled to go to trial on November 1st. Prosecutors are now asking to allow into trial a video from July 2020, which they say shows Rittenhouse striking a teenage girl in the back. His defense says the incident is irrelevant to his charges. Prosecutors also want to argue that Rittenhouse is affiliated with the far-right extremist group Proud Boys. Photos taken at a bar show Rittenhouse making a hand gesture with people in the group. Defense attorneys say race wasn't a factor in the shooting. Rittenhouse is due back in court in September. All right, so we have two prior incidents, one by the victim and one by Kyle Rittenhouse, that either side probably wants in for their own reasons. Julie, for Rosenbaum's sex registration, that was almost 2 decades ago. Could that come in at trial?
I highly doubt it. I mean, the argument from the defense is that it should come in order to show that he wasn't allowed to carry guns and he wanted to get Rittenhouse's gun, which makes no sense because after all these years, if he wanted to get a gun, he would have found a better way to get the gun other than getting it from Rittenhouse. I think the second issue is that Rittenhouse, there's no evidence he knew this guy was a sex offender, which would be in regards to the whole self-defense matter. And so I think this is really just a ploy on the part of the defense to get in evidence in front of a jury that would somehow malign and make the victim in this case look worse than they are. And so I don't think it's going to come in. I can't imagine a judge letting it in.
Absolutely, I would agree with you there, but maybe it's also they're trying to get it out into the media, so maybe the pre-jury pool can hear it as well. We'll see how that plays out. Terry, Rittenhouse striking a teenage girl is horrible, but it's a little different than shooting someone on the streets. So could that come in?
You know, Brian, it is horrible, but it's extremely different. And I think for the reasons that we just heard Julie articulate, it shouldn't come in. I mean, under Rule 404B, we know that a prior bad act should not come in unless it's showing intent or some type of scheme. And here, hitting a teenage girl has absolutely nothing to do with the charges that we have against Rittenhouse. And so it's going to be more prejudicial than it will be probative. And I definitely don't think a judge is going to allow it.
Yeah, I would agree with you both. I think that this is both sides attempting to try to carve out or to create a narrative to help either side. But I think at the end of the day, neither of them ended up coming in because they're not relevant. And I think you brought up that 404B argument perfectly, Terry, in terms of why it wouldn't come in. Terry, what about the Proud Boys aspect of this all, though? Could that come in?
You know, that could come in because I think it has something to do with motive and or intent. But the teenage girl incident shouldn't come in. I mean, if you think about Weinstein and you think about Bill Cosby and those types of cases when other incidents came in, it was relevant. This is not.
All right, we'll see how it plays out. Thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.